So you said in your speech that neither Bitcoin nor Ether would be considered securities and thus not under the purview of the SEC. Can you very briefly explain what your reasoning is?
Sure, Bob. These are complex facts and circumstances tests, but when we look at Bitcoin or if we look at Ether and the highly decentralized nature of the networks, we don't see a third-party promoter where applying the disclosure regime would make a lot of sense. So we're comfortable in some sort of viewing these as items that don't have to be regulated as securities.
An investment contract, because an investment contract is a security. This four-part test, in my mind, suggests that most, maybe not all, but most initial coin offerings are securities. Because they're investment contracts where there is an exchange of money, there's a common enterprise, you're relying on somebody else's expertise for profits. And this is why I've earlier this year said I think that most of them are. I think Ether, when it was done in 2014, would pass this test. When I say pass, it means it's a security. Now, subsequently, the SEC has said by 2018 it's decentralized enough, and they've sort of said.
But this event gives us a great opportunity to address a topic that I think has been a subject of considerable debate in the press and in the crypto community, and that's whether a digital asset, a token, a coin, offered as a security can over time become something other than a security. To start with, I'd like to frame that question a little differently and focus not on the digital asset itself and does the digital asset morph into something, but let's look at the circumstances surrounding the digital asset and the manner in which it's sold. To that end, I think a better line of inquiry might be, can a digital asset originally sold in a securities offering later be sold in a manner that doesn't constitute the offering of a security?
In that area, let me start with the technology, distributed ledger technology. Incredible promise. It can drive efficiencies not only in the financial markets, but in a lot of markets. Fine. Two areas in the financial markets where distributed ledger technology has come to the fore. Cryptocurrencies. These are replacements for sovereign currencies, replace the dollar, the yen, the euro with Bitcoin. That type of currency is not a security. Let me turn to what's a security. A token, a digital asset where I give you my money and you go off and make a venture. You have some company you want to start or something you want, and in return for me giving you my money, you say, you know what, I'm going to give you a return. Or you can get a return in the secondary market by selling your token to somebody. That is a security.
Now, subsequently, the SEC has said by 2018 it's decentralized enough, and they've sort of said, you know, we'll let it go the other way. But whether it's Ripple or EOS or others that have done big initial coin offerings, when you think about these four things, they probably...
SEC comes to work every day thinking about our Main Street investors and how to protect them.
Come to think of it, Ripple never really participated in any form of initial coin offering, which automatically takes it out of this list of supposed security offerings indicated by the current SEC chair, Gary Gensler. Yet, the SEC today has continued to maintain its case that Ripple participating in selling securities offerings. Yet, the SEC today has continued to maintain its case that Ripple participated in selling securities offerings, and still maintaining that Ethereum, which actually did carry out an initial coin offering in 2014, is not, thereby creating a conflict of ideas among XRP enthusiasts given these inconsistent statements from past and present SEC officials. Ripple never held an ICO, and XRP was never sold on the secondary market. Neither has the company ever offered future tokens to fundraise, nor has it had any agreements with the vast majority of XRP holders. Yet the SEC accuses Ripple of raising $1.3 billion in an unregistered securities offering. And this dilemma has stirred up a recent trend to present a motion before the court that XRP holders would like to participate and duly represent themselves in the lawsuit. Now the XRP community is filing to enter the case with the SEC. So is this a countdown to the end of the lawsuit? Well, let's find out. For now, don't forget to hit that subscribe button, turn on post notifications, and check out the description section for some useful links.
Speech got a lot of attention because it was the first time we had expressed to the world that we didn't view Ether as a security as it was then currently being offered. We're not talking about the original offering, and we're not talking about what it may evolve to over time, or if someone repackages it or does other things with Ether. But we're saying at the current time there wasn't really a need to regulate Ether as a security in our minds. The speech was called when Howie met Gary because of those two cases. The Howie case we've talked about.
My predecessor, SEC Chairman Jay Clayton, I think said it well in 2018 in congressional testimony. He said, to the extent that digital assets like, and I think he named Bitcoin, but he said, to the extent that digital assets like initial coin offerings or ICOs or securities, and then he goes, and I believe every ICO I have seen is a security, we have jurisdiction.
Get that out there. We also, last summer, spoke a little bit more about how we were looking at some of the more decentralized and seasoned digital assets like Bitcoin and Ether on the Ethereum network. And we made it very clear that at this point we don't see a reason to regulate those as securities or transactions in those instruments as securities.
All of us at the SEC believe that there's real value in creating applications that can be accessed and executed electronically with a public, immutable record, and without the need for a trusted third party to verify those transactions. We see the value in that, and we see the potential for that to create innovation.
Gary Gensler of MIT. Thanks for being here.
Good to be with you, Richard.
So tell me a little bit about how you made your way into this wild world of crypto.
I'm really here by happenstance. I've lived a lifetime around finance and public policy, being on Wall Street for early part of my career, and then finding my way into serving in both President Clinton's and President Obama's administrations. But it was really a faculty member here at MIT, Simon Johnson, who knew me a little bit from my work at something called the Commodity Futures Trading Commission, which I had been so honored to chair.
Heard of it, yeah.
Post the financial crisis, where we were trying to bring a very significant market, a $300 or $400 trillion market, into transparency and lowering some risk for the public. Crowdfunding offers pre-functional transferable tokens for use on a future blockchain application. And it has mixtures of economic attributes, which is both investment and consumption. So you've heard this debate. Is it a utility token? Is it a consumable token? Or is it an investment? Well, kind of the answer is it's both. I know that's not an answer a lot of people like, but that's kind of where we are right now.
Those tokens being offered, many of them are offered and sold as security.
Attorney John Deaton's initial motion to intervene was filed on Monday, April 19th, 2021, which had 6 XRP holders filing a motion to intervene, representing a putative class of users, investors, holders, developers, content providers, and businesses utilizing the digital asset XRP and its XRP ledger. At the time, the then proposed representatives of the XRP holders had been contacted by the broader XRP community of more than 12,600 XRP holders, requesting to be termed co-defendants and coveting to join the proposed intervention. However, that request, which was denied given the motion wasn't timely, the applicants asserted an interest relating to the property or transaction that was the subject of the action. These applicants were so situated that without intervention, disposition of the action may, as a practical matter, impair or impede the applicant's ability. Finally, the applicants' interests weren't adequately represented by the other parties, as required by Rule 24 of the Federal Rules of Civil Procedure. It was later accepted a few months later, sometime in October of that same year. With the court denying and eventually conceding those 6 XRP holders amici status back in the day, it's even more likely for the court to grant this latest request. Today, that putative class of XRP holders has grown significantly to more than 67,000 XRP holders. Because all parties opposed class certification, and due to such concerns regarding delays, the court granted amici status to the XRP holders in their individual capacities. Although the public interest in this case, personified by those 67,000 holders of XRP, can't be overstated, the amici request continues to seek leave acting in their capacities. This has resulted in attorney John Deaton entering the lawsuit, this time with an overwhelming number of entrants. And as he writes to the court, Deaton requests the court to write a brief on behalf of other community members who've been affected by the lawsuit. A move that was brought into play following the potential introduction of the SEC's favorite expert testifier, Patrick Duty, whose report aims to explain what motivated XRP holders to buy the token. So, the XRP community is entering into the Ripple versus SEC lawsuit through the John Deaton-led Amici request to file an amicus brief regarding the plaintiff's expert. John Deaton and the XRP community believe that Amici will provide the court with a suggestive perspective of these XRP holders, just as it helps ensure a comprehensive and planetary presentation of complex issues. The court may reach a proper decision and come to a resolution much quicker. So, looking at the upcoming Delbert challenge on Mr. Duly, how do we know, and how do John Deaton and the 67,000 XRP holders and counting know what Mr. Duly would say when neither party is yet to get their hands on the said report? Well, let's listen to the expert. So, who is this guy, and what's his role with the commission? Well, according to his report for the SEC in the Telegram case, it says, "The SEC has retained me to independently analyze and opine on the perspective of a reasonable purchaser of the digital tokens called grams that were offered for sale by Telegram in 2 rounds. From that, we can see that Mr. Duly is the SEC's go-to guy for such matters regarding expert testimony on behalf of the so-called reasonable purchasers of the said digital asset. And as it says here, according to Mr. Duly, I conclude that it was reasonable for a purchaser to buy grams in round 1 and round 2 with the expectation of profit derived from the work of Telegram in developing the TON blockchain ecosystem. Without going through the process of seeking a deposition from an actual holder of that coin or asset, so taking that into consideration and taking the Telegram case as a case study, we could essentially guess what Mr. Duly's response in the Ripple versus SEC lawsuit would look like. Now, putting that into context and replacing Telegram with Ripple, the TON ecosystem blockchain with the XRP ledger, we get an almost perfect idea of what his response regarding the Ripple versus SEC lawsuit would turn out to be.
Add is the other elephant in the room, I think, is the lack of clarity that has gone on in this industry. And, for years, I think the crypto industry has asked for that clarity. And yet, we're still getting this kind of, hey, yesterday we heard it is clear, yet a few weeks ago, we had 2 commissioners and Pearson Roisman saying, a letter, and I'll quote, they said a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading. So to me, one of the elephants in the room is we can't keep saying it is clear and then trying to make it clear through enforcement. You see other G20 markets like the UK, like Japan, like Switzerland, like Singapore, who have been proactive and engaged. And that has helped these markets thrive in those countries. If the US wants to be a leader in this space, then we need to provide that clarity and not act like there is clarity.
Guys, it's time to take the bull by the horn. To achieve this, all hands need to be on deck. It's time to get off the spectator's booth and actively participate in this lawsuit, at least if you're a fan of XRP or you believe in the future of crypto, and want to air your voice on the unfair treatment the foremost crypto regulatory agency in the US has been exerting upon crypto and blockchain companies in the country. So sign the form, linked in the description, today. That's all I have for you folks. If you enjoyed the video, hit the like button. Don't forget to subscribe if you haven't already. And as always, we'll see you in the next video.